Today we are discussing about the case Murlidhar Chiranjilal versus Harishchandra and another. Before going to discuss about the facts of the case, I seek your attention to a relevant section of Indian Contract Act 1872, that is Section 73. As we all know that when one party of a contract breaches a contract because of which the other party suffers damage, it allows to the aggrieved party the right to be compensated for the loss caused. When such a breach of contract takes place in India, Chapter 6 of Indian Contract Act 1872 comes to play. Section 73 talks about the law in relation to the damages for a breach of a contract and the standard for remoteness of the damage caused. It is clearly mentioned in this section that no compensation is required for any remote or indirect loss which has been sustained due to a breach of contract. The landmark case Harley versus Baxendale laid down the test which measures remoteness. The test has two conditions, and the aggrieved party needs to prove that the loss they suffer falls into one of these two conditions, which makes the party which breached the contract liable for the loss. The first contention is damage which naturally arose in the usual course of things from such breach, and second one is which the parties knew it to be likely result from the breach. Now let's look into our case, that is Murlidhar Chiranjilal versus Harishchandra Dwarkadas. It is one of the landmark cases where Section 73 came to play. In this case, the appellant, that is Murlidhar Chiranjilal, entered into a contract with the respondent for the sale of certain canvas. The cost of transport from Kanpur to Kolkata and the labor charges in that connection were to be borne by the respondent, and it was agreed that the railway receipt would be delivered on August 5, 1947. The appellant was unable to deliver the railway receipt on the due date because booking from Kanpur to Kolkata was closed and therefore cancelled the contract. The respondent instituted a suit for the recovery of damages for the breach of the contract and claimed that as the seller knew that the goods were to be sent to Kolkata and would be sold in Kolkata, any loss of profit to the buyer resulting from the difference between the rate in Kolkata on the date of the breach and contract rate would be the measure of damage. The Supreme Court applied the second condition of Section 73 that I had already mentioned and held that there was a breach of contract. However, the party which breached the contract did not know that the can was meant for sale only in Kolkata and could not have contemplated the same at the time of entering a contract. Hence, no special damages would be provided to Murlidhar, and only the damages which would arise at the rate of sale of the canvas in Kanpur were provided. One more point that I want to add in is the importance of impossibility of performance of the contract. Here in this case, the appellant cancelled the contract due to the failure faced by them in the delivery of the railway's receipt on the due date, as the booking from the Kanpur to Kolkata was closed. This was the one of the contentions raised by the appellant. However, this was challenged in High Court on appeal. The High Court held that the contract had not become impossible of performance, as it had not been proved that the booking between Kanpur and Kolkata was closed at the relevant time. Section 56 of Indian Contract Act says that an agreement to do an act impossible in itself is void if the parties enter into a contract and at that time of entering it was possible to perform the contract, but due to some supervening reason or factors beyond the control of either of the parties the performance of the contract become impossible. Agreements of such a nature are void. Sometimes there may be alteration to situation where performance is not practically cut off but only rendered more difficult or costly. Such cases do not fall under the scope of Section 56. There is a case, Ganga Sharan versus Ram Charan Ram Gopal, where there was a contract of sale of certain quantities of cotton manufactured by Victoria Mills at Kanpur. This means that the respondent agreed to procure cotton from the mill and sell it to the appellant, but owing to some reason or issues, Victoria Mill was unable to supply cotton to the respondent, and the respondent pleaded the impossibility of performance. But the Supreme Court held that respondent to be liable, stating that the performance did not become impossible as the respondent could have procured the similar quantities from another mill and delivered to the appellants. The object was to deliver certain quantities of cotton, irrespective of the existence or non-functionality of the mill. So I mentioned this case because of I feel some similarity in this case and the today's discussion case, that is Murlidhar Chiranjilal versus Harishchandra Dwarkadas, and these all are my analysis. Thank you.
Today we are discussing about Murlidhar Chiranjilal versus Harishchandra Dwarkadas 1961. In this case, the appellant who had entered into the contract for a sale of canvas at rupees 1 per yard with the respondent, but in the delivery was to be made to a railway receipt for Calcutta for Kanpur. So the labor charges and transportation charges were to be paid by the respondent, and the receipt was to be delivered on 5th August 1947, but the appellant could not do so because the booking was closed. Section 73 of Indian Contract Act was applicable in this case to determine the quantum of damages. So we know that Section 73 of Indian Contract Act deal with the compensation of loss or damage caused by the breach of contract. And this section which says about if a contract has been broken, the aggrieved party is entitled to be compensated by the party who has broken the contract. The damages might be in ones which arose in the natural course of breach, or both parties are aware of damages which may arise due to the breach of contract while entering into the contract. However, in this case of remote or indirect loss, no compensation is due. There was certain case laws regarding relating to this section 73 of Indian Contract Act. Section 73 of Indian Contract Act, which incorporate to the rules of landmark judgment, Hadley versus Baxendale in 1854, and it is in English case. So in this case, the compensation for loss or damage is recoverable if it arises naturally from the course of things from which the breach or which parties knew at the time of contract as likely to result from the breach. So in this case, the court acknowledged that defendant's failure to perform the task was only the reason for the loss that the plaintiff suffered. Another case is Sanico Limited versus Coffers. And in this case, there was a contract for carriage of cargo of sugar, which was delayed by 9 days. Unfortunately, due to the arrival of another cargo sugar, the market price of sugar dropped. The plaintiff sought to recover the damages. I mean, the difference between the original and increased market price. It is due to the breach of contract. But it was argued that the market price was likely to increase and the loss was also too remote. It was held by the court that since the defendant should have known about the fluctuation of market prices, he would have to pay the loss for breach of contract. Another case is Simpson versus London. In this case, the court held that if a party breaking the contract knows the special circumstances, then he is liable and the communication of same is not necessary. So when we begin to analyze Section 73 of Indian Contract Act, it only states the Section 73 of Indian Contract Act states only about the damages caused by the breach of contract arising during the natural course of things, and there is no mention about the indirect loss or damage sustained due to the breach. And Indian Contract Act does not have any provisions for the compensation of losses of contract which would have been termed void. Thank you.